All right. Good afternoon, everyone. Welcome. What, are we recording? We're good?
Yeah, I was talking to Wes. Sorry.
Oh, okay. Oh, okay, so the hands on. All right. Well, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. This is our briefing on auto charging of youth. We're going to start off with basically a primer and a background of the current law from our counsel, Josh Prada. Then we'll move on to the Department of Juvenile Services, Kara Annison, and then we'll move on to Nick Maroney, and then Margie Josie, and then we'll wrap up with Nate, or Nathaniel Bayless, who's the director of the Juvenile Strategy Group, the Juvenile Justice Strategy Group. Obviously, in this committee, we've made some significant changes to the juvenile justice system over the last couple of years, and so this briefing today will provide us with kind of a base level understanding of how everything functions, as a broad analysis of how those decisions are made in terms of charging youths as adults, the validity of that. We'll talk a little bit about some of the science and some of the research at the national level as well, and then we'll dig into the process for Maryland. So with that, we'll start off with our counsel, Josh Prada.
Thank you, Mr. Chairman. So as you said, I'm Josh Prada. I'm committee to the council, and I'm just going to give a very brief overview of the underlying law here before I turn it over to our panelists. So the court's article of the code establishes that a circuit court may sit as a juvenile court to hear certain matters involving juveniles, including juveniles who are accused of committing acts which would be crimes if committed by adults, which are referred to as delinquency proceedings. Generally speaking, juveniles who are accused of delinquent acts are tried in the juvenile court. However, there are certain categories which are carved out of that, under which juveniles are automatically charged as adults in adult court. So for the purposes of this briefing, the three categories of carve-outs that we're looking at are juveniles who have previously been convicted as an adult of a felony and are now accused of another felony, juveniles at least 14 years or older, alleged to have committed any act punishable by life imprisonment, which specifically is first-degree murder or first-degree rape, and juveniles at least 16 years old, alleged to have committed any one of a list of enumerated offenses in the statute. In 2019, the Juvenile Justice Reform Council was created by statute and was tasked with studying best practices and recommending statutory changes for the juvenile justice system in Maryland. In 2021, the council issued its final report. Among its recommendations were the elimination of automatic charging of juveniles as adults. However, many of the members of the council did not participate in that vote, and therefore that recommendation was not included in the bill which the General Assembly passed last session, which generally implemented the recommendations of the council. A juvenile who is automatically charged as an adult may petition the court to transfer the case to juvenile court. In order to grant that motion, the court must find by preponderance of the evidence that the transfer is in the best interest of society or the child. The statute provides a list of factors that the court is required to consider, the most significant of which is the child's amenability to treatment by the Department of Juvenile Services. The Department of Juvenile Services is the agency responsible for providing services and treatment to juveniles who are going through both the juvenile and adult justice systems. And so with that, I'll turn it over to Kara Annison, who has more to say about the role of the department.
Can I ask you a quick question? I control my slide.
Yes.
All right. Good afternoon, Mr. Chairman, Mr. Vice Chairman, and members of the committee. My name is Kara Annison. I'm the Director of Legislation, Policy, and Reform at the Maryland Department of Juvenile Services. Thanks so much to the committee for the opportunity to discuss the operational impact of automatically charging youth as adults on the Department of Juvenile Services. So before we jump into some of the data slides, I thought it would be important to be clear about a few key terms. So youth in Maryland as young as 14 can be automatically charged as an adult if they're charged with first-degree murder, first-degree rape, or a first-degree sex offense. Youth who are 16 and older can be automatically charged as an adult if they're charged with a crime of violence or a handgun possession. A youth may request a transfer hearing from the adult system to the juvenile system. Transfer is prohibited for youth that are 16 and 17 years old and charged with first-degree murder. For cases starting in the juvenile court, a youth may be waived to the adult court if the youth is 14 and over and charged with first-degree murder, first-degree rape, or a first-degree sex offense, or if they're at least 15 years old, regardless of the offense. Since 2015, the Maryland Department of Juvenile Services has successfully housed the majority of youth charged as adults in their detention facilities. In fiscal year 2022, 112 youth were waived to the adult system. So they started their case in the juvenile court and were waived up to the adult court, and 631 were automatically charged as adults. As you can see, the overwhelming majority of youth who were charged as adults in Maryland were 16 and 17 years old, Black, and male. This is consistent with the research that shows that Maryland leads in the disproportionate incarceration of young men of color. So now we're going to talk a little bit about the process. When a youth is automatically charged as an adult, they're booked and processed in the adult jail. They wait in the adult jail for their bail review hearing. The youth can ask to be held in a juvenile detention facility pending their transfer hearing. A bail review typically happens 1 to 3 days after they initially were processed in jail. Due to COVID, sometimes bails took longer than the 1 to 3 days, and often youth who had an order to wait in juvenile detention facilities were delayed due to COVID issues and medical clearances from the adult system to the juvenile system. Maryland's Juvenile Justice Compliance Monitor found 651 sight and sound separation and jail removal violations in federal fiscal year 21. This may put the state out of compliance with federal law and lessen the amount of federal dollars the state receives. Then the youth requests a transfer hearing, and that starts the Department of Juvenile Services work. So we complete evaluations, assessments, and reports, and this typically takes the department 30 to 60 days. Then the youth has a transfer hearing, and what we know is about 85% of youth that are automatically charged as adults either have their case dismissed or returned to the juvenile court. So youth wait 114 days, the equivalent of a school semester, just to have their case dismissed or restart in the juvenile court. Then the youth moves to the juvenile system. A youth is recharged in the juvenile court, and the department completes new and additional assessments and evaluation in preparation for disposition. Once the case is restarted in the juvenile court, it takes an average of 60 days for the process from recharge to the youth either getting probation or treatment. So to recap, about 85% of youth wait an average of 114 days to have either their case dismissed or sent back to juvenile court. If all youth were to start in the juvenile court at the end of about 60 days, youth would either be connected to services or waived to the adult system. And the department would cut about 114 days of unnecessary detention. This is in alignment with why the juvenile court system was designed to take into account the developmental needs of youth. And research tells us that we get better outcomes when we quickly hold young people accountable and provide them services that meet their unique treatment needs. So what happens to young people that are charged as an adult and have their case transferred back to juvenile court? 70% of kids are treated in the community. 45% get probation, and 26% of them have their case dismissed. Only 28% get a commitment court order. The Department of Juvenile Services has a strong continuum of programming with more than enough capacity to serve the under 30% of court-ordered youth to an out-of-home placement. So next we're going to talk about recidivism. Youth charged as adults have a very low recidivism rate. Their recidivism rate is lower for both probation and commitment than their counterparts that start in the juvenile system. So I just want to take a second to explain this chart to you. So young people that get a commitment order or an order of probation are 7.1% recidivism rate. Youth charged as adults that get transferred back to the juvenile court and get a court order for commitment have an 11.4 recidivism rate, which is lower than the young people that start their case in the juvenile court. Maryland's highest court signaled in the Davis decision that young people should be served in the juvenile system because public safety is improved, not harmed, by the rehabilitative aims of the juvenile system. Specifically, Judge Wilner asked in the Davis decision, is there a program that can provide immediate safety to the public and make recidivism less likely? And he concluded, in the opinion, if so, absent some other circumstances, the child should be transferred to or remain in the justice system. When we look at public safety and correctional services emerging adults population, which they classified the emerging adults population as young people between 18 and 25, and we look at their recidivism rate, it is 45%. Often, Patuxent is looked at as a comparable option to the juvenile justice system, but when we look at who they're actually serving, the average age of a Patuxent inmate is 37 years old. The majority of them have a sentence that is over 30 years, and about 50% of them are there for homicide cases. So let's look at the human impact of charging youth as adults. 85% of youth spend an average of 114 days in the adult system just to restart their case in juvenile court. 85% of youth spend time in adult jails not receiving education, are subject to isolation, and are absent adolescent interventions to meet their acute needs. And we know that 70% of youth have their cases transferred back to, or are treated in the community. To sum up, the operational impact of charging youth as adults has on the Maryland Department of Juvenile Services. It's ineffective, it strains our resources, and it impedes our ability to hold youth accountable and provide effective treatment. And as you saw, when we treat young people in the justice system, we have better public safety outcomes. So this last slide that I have for you all just has all of the resources and data information. And I think I'm going to turn it over to Nick Maroney, who has a few remarks.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Nick Maroney. I direct the Juvenile Justice Monitoring Unit, which is a monitoring unit, an independent monitoring unit run out of the Attorney General's office that for the last approximately 20 years have conducted unannounced visits to DJS facilities, both the detention facilities and the placement facilities, so both the jail equivalent for kids and the prison equivalent for kids. Part of our duty also is to report both to the legislature and to agency heads and to the general public through the Attorney General's website what we find in those facilities. And our main job, our main purview is to guarantee to kids what they need while they're in juvenile facilities and to guard against abuse. So the reason that we were founded and legislatively mandated initially, even though the Department of Juvenile Services had and still has its own internal mechanisms for looking at their own system, is that there was widespread abuse. Some of you may remember that Maryland embraced a boot camp model, which went seriously south, and there were a lot of kids abused. Since that time, the juvenile system has frankly come on in leaps and bounds. There are less kids involved in the deep end of the juvenile system, and there are more services and more transparency than there was in the past. Unfortunately, there's no such equivalent oversight of the adult lockups or the corrections facilities, or the sheriff's detention centers, none whatsoever. And so kids there, while they're not on the one hand invisible to us all as to what happens, generally they're not really getting services. These places are not run for kids. Most of the folks who run these places don't know what to do with those kids. And the absolute zenith of their wish is to be in accord with the federal mandate that they keep the kids separate from the adults. If they do that, they reckon they've done everything they can, and that's called sight and sound separation. Again, unfortunately, what that usually means is that the kids are subjected to what amounts to seclusion or solitary confinement for most of the day. And there's no education services, et cetera, et cetera, et cetera. So, no adult equivalent for that, for our unit. As I said, our job is to ensure kids are receiving what they need so they can function while they're incarcerated, and also so they can function, so that they have what they need through DJS or other agencies so that they can function once they're in the community again. You know, the kids that are charged and held as adults are not getting any of this stuff. Juvenile facilities, I do want to quickly make a point, because sometimes folks have a slightly inaccurate view of what a juvenile detention facility looks like, or how it operates, or what all is involved in a juvenile detention facility. The number one thing I want to stress is that juvenile detention facilities, as operated by DJS, are maximum security facilities. They're sometimes called hardware secure, which is another term of art that amounts to the same thing. They're maximum security facilities. So the notion that perhaps some folks may have that holding a child who has been charged with something serious in a juvenile facility is somehow going to lead to a situation where there's less security around that kid is not accurate. The Baltimore City Juvenile Justice Center, that's a maximum security facility. The facility out in Cheltenham, the detention center, that's a maximum security facility. Sometimes I've heard even state's attorneys say that the facility, the Hickey facility in Parkville in Baltimore County, is not high security. Unfortunately, that's not accurate. It's very high security. It's a hardware secure facility. So kids who are charged as adults currently and held in a juvenile facility are subject to maximum security facility strictures. I think that's important to note. So one of the things Kara mentioned was the tremendous amount of time that's wasted for a kid who is charged as an adult. And not just in terms, I think Kara mentioned education, and that's extremely important. But it's not just education. It means that nothing is done to explore why what happened. The court hasn't heard anything from the kid or made any decisions. There's no individualization. The whole entire treatment so far of the child rests on the fact that they were charged through the police, through the state's attorney, through the prosecutor, a certain way. And so there's a lot of detrimental effects on a kid who is stuck in that situation, and it's not just education, it's mental health, because you can't provide services, et cetera. It's not just education, but mental health too. So another thing I wanted to point out is that exposure to the adult criminal justice system is extremely harmful to kids. They have a much higher suicide rate. They're much more likely to be abused, and as I mentioned, there's no oversight to try and guard against that kind of thing happening. The recidivism rate is also, amongst the adult incarcerated community, the recidivism rate of the youngest prisoners is highest. So if we're looking for safe communities, then we need to keep the kids where they can get services, and that's in the juvenile justice system. As Kara also mentioned, the recidivism rate amongst those kids who are in the juvenile system, despite being charged, quote unquote, as an adult, their recidivism rates are amongst the lowest of the kids in the juvenile justice system. So I think that does speak for itself. So in essence, expanding the juvenile court jurisdiction purely, in my view, from an objective point of view, would promote public safety rather than the opposite. Because the juvenile justice system is mandated to provide mental health services to kids, it's mandated to provide education services to kids, and the staff who kids would be under the care of are used to kids, and their training is geared towards working with kids. And with that, I will move to Nate from the Annie Casey Foundation. Thank you so much.
Mr. Chairman, Mr. Vice Chairman, and members of the committee, thank you for inviting me here today to share evidence, best practices, and a national perspective that I hope will put Maryland's current approaches in context when it comes to charging youth as adults. Again, my name is Nate Bayless. I work at the Annie Casey Foundation in Baltimore, where I lead our juvenile justice team. As an organization that seeks brighter futures for children, families, and communities around the country. We spent more than 3 decades focusing on improving how youth and communities are served by the justice system, funding research and supporting best practices aimed at improving outcomes for young people. I had the privilege to serve with some of you on the Juvenile Justice Reform Council, which again was established in 2019 through Senate Bill 856, and which had very clear-minded goals that I believe are really important and really are guiding this briefing today. So I want to repeat them because I think it's important to give context to this issue of youth who are charged as adults. These were what we were charged with on the Juvenile Justice Reform Council. We were charged with using a data-driven approach to develop a statewide framework of policies to invest in strategies to increase public safety and reduce recidivism of youth offenders. Number 2, we were to research best practices for treatment of juveniles who are subject to the criminal and juvenile justice systems. And finally, we were to identify and make recommendations to limit or otherwise mitigate risk factors that contribute to juvenile contact with the criminal and juvenile justice systems. I think these are good guiding principles for talking about any youth justice issue, and whether we're talking about data, whether we're talking about best practices, or whether we're talking about limiting risk factors, it's quite clear that charging children as adults is not a good approach. The first juvenile court was established nearly 125 years ago. Next year it'll be 125 years. Because of the understanding then, back in the late 1800s, that children were different than adults. A century later, a vast body of research on adolescent development and the adolescent brain has provided more evidence that youth are different than adults and warrant different responses. Kara and Nick spoke of at least 6 issues with charging young people as adults here in Maryland. So I'm going to try to quickly talk about each one because I hope they can give perspective, again, about this issue and why it's so important. The first is effectiveness. The research is really clear and overwhelming that charging youth as adults is simply not effective if our ambition is to see positive outcomes for community safety and young people who offend. The Task Force on Community Preventative Services, which was comprised of researchers, including those from the Centers for Disease Control, the National Institute of Justice, the National Institute of Mental Health, found that, and I'm going to quote here, available evidence indicates that transfer to the adult criminal justice system typically increases rather than decreases rates of violence among transferred youth. On the basis of these findings, the task force recommends against laws or policies facilitating the transfer of juveniles to the adult criminal justice system for the purpose of reducing violence, end quote. This doesn't even touch on the broader life chances where young people who are sentenced as adults carry a felony conviction for their entire lives, hurting their employment prospects, housing access, their ability to go to college, joining the military, or even vote, depending on where they are. So effectiveness, number one. The second issue, which is really closely related, and this came up a couple of different places, so I just really want to emphasize this, is that offense severity does not equal risk to public safety. So as Kara said, because it's a striking statistic, youth with the most serious offenses in Maryland have lower recidivism rates when placed on probation or committed to state custody than those with less serious offenses. And Nick mentioned as youth's behavior in Maryland's facilities is not correlated with offense severity. So when they're in these juvenile justice facilities, the kids who are causing most problems or getting the most trouble, it's not impacted by offense. Those things are not connected. Now, I think for the committee, this may sound counterintuitive because the responses in our justice system are so heavily offense-driven, both in the juvenile justice system and the criminal justice system. But this is consistent with recidivism studies around the country for years and years that show offense is not a predictor of future offending. It also, though, and I think this is really important to, especially where Nick was hitting on, that the importance of treating youth as individuals, something that is very core to best practices in juvenile justice, and something that juvenile justice often gets wrong. But when we're doing it right, that the hallmark of every intervention that is proven effective is when we individualize what we do with young people. By treating all 16 and 17-year-olds charged with 33 different offenses as adults, Maryland misses that. We end up not treating young people as individuals, and instead we're treating them all the same. We need to focus on the individual circumstances of offenses when we're working with young people and have individualized approaches that will work best with each young person. That's what makes us most effective. So it's just really important that we're making sure we're hitting on that. Third thing is timeliness, and this came up. Accountability and rehabilitation are both important parts of the justice system, but they should be as immediate as possible. I have a 12-year-old and an 8-year-old. Any of us who are parents or who have worked with young people know that when our kids do something wrong, when we respond is sometimes as important as how we respond. Timeliness matters. As Kara showed, youth are waiting twice as long for their cases to be resolved when charged as adults than when they're charged as juveniles. Waiting for months on end while the criminal justice system slowly processes youth's cases is not just a problem here, it's a problem all around the country when young people are charged as adults. When kids offend, especially if their offenses harm others, it is paramount that our responses are individualized, effective, and timely. Fourth issue is about services and supports. On a related note, while young people's cases are moving through court, they should be in school and receiving mental health services and other services that are helping them, whether they're detained or in the community, something that has to happen within the juvenile justice system and does not happen when young people are held in jails. Fifth issue that came up is about equity. The disproportionate impact of charging youth as adults is not just a problem here in Maryland. Around the country, the disparity among youth charged as adults is even worse than it is for youth who are sent to youth prisons in the juvenile justice system and other out-of-home placements. It's also important to note that these disparities are much worse than the disparity in youth facing charges for the most serious offenses. In other words, based on national juvenile court statistics, in 2019, among youth who were charged with person offenses, black youth were twice as likely as white youth to be waived to adult courts. And I point that out because I know we're always eager for those apples-to-apples comparisons, is the reason why there's different treatment because of what the behavior is. Same offenses, different outcomes when it comes to black and white youth. And the final issue that came up is about safety while young people are detained. I think one of the most striking problems of charging young people as adults is that every young person begins in jail, and some stay there. I think half of the core requirements of the federal law governing juvenile justice, which is called the Juvenile Justice and Delinquency Prevention Act, or JJDPA, focus on keeping youth out of adult jails. JJDPA requires that youth not be held in adult lockups, and it requires sight and sound separation, as Nick talked about, from adult inmates in any facility. If we couldn't tell, research tells us that youth held in adult jails are far more likely to commit suicide than youth in juvenile detention centers. And in order to comply with federal laws around sight and sound separation, as Nick pointed out, young people are oftentimes held in isolation. So I think it's important to note that around the country, and I'd like to just sort of take a moment to compare Maryland, states have rapidly moved away from the punitive practices of the past, especially in the 80s and 90s, that saw virtually all states making it easier to charge young people as adults. Maryland was one of the very first states to automatically charge some young people as adults way back in the 1940s. We were the first state to automatically charge children as adults for robbery back in the 1970s. Even as other states began to pass automatic transfer laws in the 1980s and 1990s, Maryland's list of offenses was longer. Now, since the turn of the century, 44 states have rolled back laws that make it easier to send youth into the adult system, including states ranging from California, New Jersey to Kentucky and Florida, who have ended entirely the automatic transfer of youth to criminal courts. Other states have been limiting eligibility for charging youth as adults through raising the age or the charges that are eligible. In totality, these changes, as well as Maryland's history in this area, has made Maryland an outlier today when it comes to our practices for charging youth as adults. When the Sentencing Project looked at the most recent year of data across states for youth charged as adults, it found that Maryland had a higher rate of charging our children as adults than any state other than Alabama. And it wasn't very close. And that was a chart that was put up for the Juvenile Justice Reform Council. But let's break that down a little bit further, so just to give a sense of the volume and what we're talking about. Those data tell us that Maryland charged roughly the same number of children as adults as Arizona, California, Colorado, Connecticut, Illinois, Kansas, Massachusetts, Minnesota, and Ohio combined. Those states total about 29% of the youth population around the country, whereas Maryland's youth population is less than 2% in the country. We charge roughly the same number of children as adults as the state of Florida, a state with 3 times as many children and with a notoriously punitive justice system. So I'm going to end here. I want to just say, going back to, again, the Juvenile Justice Reform Council responsibility, by focusing on data-driven approaches, best practices, and reducing risk of future offending, Maryland has positioned itself for a much stronger and more effective juvenile justice system going forward, one that I believe will be very prepared for working with young people, all young people. In appointing Vinnie Schiraldi, Governor Moore has appointed a leading expert in juvenile and criminal justice to lead the Department of Juvenile Services, someone who has experiences leading agencies both on corrections for both juvenile and adult, and on community supervision and support. The juvenile justice system in Maryland has never been better positioned to serve young people who break the law, including perhaps those people who commit the most serious offenses. So thank you.
Excellent. Thank you very much, Nate, Kara, and Nick, very, very much for the presentation. We'll now switch to the committee for questions, and we'll start off with Senator West.
Thank you, Mr. Chair. So, Ms. Ananson, could I ask you a question first? Your slide 3 shows that 743 youth were charged as adults in fiscal year 2022. There is no companion slide that indicates how many youth were charged as juveniles during fiscal year 2022. Do you have that information?
I can get you that information. I can pull it up in a second. Yes.
Are we in a second?
Yeah, I can pull it up.
Okay.
If you give me a minute.
Yeah, go ahead, and maybe I can ask another question first
Yeah.
while you're pulling it up.
Yeah, go ahead.
To
somebody
maybe
else.
somebody
Okay.
else, if they can do it. You may need to answer the question. My question is, well, first of all, let me get this.
I can get you that. We can get it. I can get it to you after if we're done. I can get the number of youth. You want the total number of youth that were charged as youth in the state?
As juveniles in
Yep.
fiscal year 2022.
Yep.
Are we talking about a larger number than 743 or a smaller?
Larger.
Larger. How much larger? Two times as much? 3 times?
Probably.
2 times would be a
Yeah.
fair estimate?
That coming in on a complaint, correct.
So around 1,500.
It's probably about that.
Okay. So the one thing I didn't hear any of you talk about was the fact that if someone is convicted as a juvenile and sent to jail, to juvenile incarceration, on that person's 21st birthday, no matter what the crime was, that person walks free. Isn't that correct?
Juvenile court jurisdiction ends at 21. That's correct.
Right. So if, just to give an example, a young man, 17 years old, kills both of his parents and his younger brother, and he gets tried as a juvenile and committed to an incarceration facility at the age of 18 when the trial occurs. 3 years later, when he's 21 years old, he walks out free. Right?
You're right, but I think, that's a judge is making that determination.
Well, of
right?
course.
They're looking at that case, they're making a determination about what system is best to handle that young person.
Yeah,
And then
but if we charge all juvenile crime in the juvenile system, then that would mean that the highest, that whoever gets convicted walks out of jail when that person turns 21. Whereas if the person is charged in the adult system, the person could serve 10 years, 20 years, 40 years, life perhaps in prison.
Yeah, and I think that, the system accounts for that. There's still a waiver, right? So when a complaint comes in and the state's attorney feels like that case should be moved to the adult system, the state's attorney can file a waiver petition and ask for that case to move up to the adult system. And so that can be handled right at the very beginning. So we're talking about the automatic charging right now. So young people can start their case in juvenile court. The state's attorney can review that case and say, you know what, this case should go to the adult system. It goes in front of a judge. The state has the burden of proof. They can go through, they can say, you know what, that kid is better served in the adult system, and maybe that case moves up. Otherwise, the case would remain in the juvenile court. The juvenile judge would then make a determination on what the level of care is best for that young person, and then they would get treatment in the juvenile system.
Well, but that's the current system. So, of the 741 youth charged as adults in fiscal year 2022, was it 743 youth charged as adults? How many of those youth ended up being tried in the adult system?
It's about, well, we were saying 85% either have their case dismissed, so it's about 15%.
I'm sorry.
I can't do the math. Hold on.
15%?
Yeah.
15% are tried as adults. And of the cases that were started in the juvenile system, how many of those are waived up so that they're tried as adults?
So we talked about that 112 number. Those are cases that originated in the juvenile court.
Okay.
And then moved to the adult court. And
Okay,
the
so that all of those
630
112
I'm
are
sorry.
tried as adults. And of the other 631, 85% of them are sent back to the juvenile court, so,
That 112 is charged with youth waived up.
Correct.
right. So that means they're going to be tried in the adult system.
Now they are, well, yes.
Right. And of the other 631 that started in the adult system, 85% of them go down to the juvenile and 15% stay in the adult system, correct?
85% of them either have their case dismissed in the adult court or have their case transferred back to the juvenile system.
Okay.
15% of them move forward in the adult system.
In the adult system.
Yes, and I don't have data on what happens to that 15%.
Okay. Answer this. How many people are currently in between the ages of 18 and 21 in the juvenile system? How many people are incarcerated that are between the ages of 18 and 21? The information I have is that most are released by their 18th birthday, and there are not many who stay in the juvenile system between the ages of 18 and 21.
That's accurate. The
How-
smallest percentage of our population is probably that age.
Right. So I guess my question is, can't we come to a determination based on the nature of the crime as to which individuals are most likely to end up in the adult system being tried, and which individuals are most likely to end up in the juvenile system being tried, and start them from scratch in those respective systems, so that it would be an unusual situation for a state's attorney or a public defender to want to try to move one to the different system from where it started?
I think right now what we're seeing is that kids are automatically charged as an adult, right, based on their age and their offense. And so the system as it currently is designed would allow, if we stop that process, would currently allow cases to start in the juvenile court and then move them up as they're needed.
Okay. So we're really talking about three things here. We're talking about where the trial should occur, where the person should be incarcerated or held prior to trial, and the transfer waiver system of moving people from one system to the other. And during your presentations, I thought they got a little bit confused, because it may be, because I think it sounds like all three of you agreed that there are some people under the age of 18 who ought to be tried in the adult system, correct? Does anybody disagree with that?
I wouldn't make that determination. I think that the part you left out was that this is also about the burden of proof and any evidence. Right now, we have a system that is solely based on the type of charge brought by law enforcement and a prosecutor. And that's an allegation. And so if we're going to have a system where justice is the ultimate goal, then what you want to do is you want to look at it on an individual basis, see what evidence there is, see what how much the burden of proof has been met, and then make an informed decision as a court as to where that person best belongs. And what we have now is an automatic system, which means that prosecutors, frankly, don't have to do any of that. And so, to me, that's not a fully functioning justice system.
All right. So let me ask my question again. Is it not the case that all three of you believe that there is a place for juveniles to be tried in the adult system?
I think that we're saying that the judge is in the best position to make the decision on what should happen with that case.
Well, that wasn't my question. My question is, do you agree or not that there are some juveniles who ought to be tried in the adult system and sentenced to jail by the adult court for adult periods of punishment?
And I guess what I'm saying to you is my answer is that I think that the judge is in the best position to make that decision.
All right, so you're not going to answer the question I asked you.
I think I answered the question that you
No,
asked
you
me.
didn't. I asked, do you believe that there are some people, some juveniles, who should be tried in the adult system and receive adult sentences?
I think there should be a mechanism that allows for some juveniles to go in front of a court and have a court make a decision whether or not that case should be in the juvenile or the adult system.
Okay, thanks.
All right. Thank you, Senator West. I'm going to move on to Senator Folden, but before you talked about burdens of proof, I just wanted, the one thing we didn't discuss in your colloquy what is, for the waiver transfer process, the burdens for waiver and transfer. Can you just walk us through that first, because that's important to your line of inquiry?
Right. So the burden in a transfer hearing, that's when the youth starts in the adult court and is moving to the juvenile court. The burden of proof is on the youth. When a case is moving from the juvenile system to the adult system, then it's on the state's attorney.
Excellent. Senator Folden.
Thank you, Mr. Chair. So I was curious, Carol, what was the number of juveniles remanded to adult court? And do you have that broken down anywhere categorically by the numbers and by the offense? So is there something, maybe I walked in late, is there something
Okay.
that, I know I did actually, so not maybe.
Not
Maybe I
maybe, it's not a
missed this
maybe.
part.
It's okay.
Is there something, it seems like we're talking about penalties, I guess, the overall penalty. Do we have it written down categorically by offense that would move them up to, for certain offenses?
So
Can
you're
I-
asking, so kids are automatically charged as an adult if they're 14 and older, charged with first-degree murder, first-degree rape, first-degree sex offense. They're automatic, or if they're 16 or 17 and charged with a crime of violence or a handgun violation, they're automatically in the adult court.
So that was kind of like where my point being. So we're talking about the serious allegations, the serious offenses that would lead to charging where there is, RAS to affect such an arrest or charging document. So I don't understand where on these offenses, especially these offenses, when, it should be concerning to all of us, and we need to use this as a dual-pronged approach in that maybe there's some mental health issues that we need to address, but there's still the criminality portion of this. So when Nate, when you said about, past performance isn't necessarily a predictor of future behavior, I completely disagree with you on that. Past performance is the best indicator of future behavior. And people that have this issues or have done these crimes, these are serious crimes. We're not talking about going and stealing something from the corner grocery store. We're talking about the most serious offenses in our own criminal justice system. Can we agree on that?
Yeah, they're serious offenses, but I think what we've been talking about today is that when we look at what's happening to kids that are automatically starting in the adult court, the majority of them are getting transferred back to the juvenile court. right? And then the Department of Juvenile Services is treating them, and then when we look at the outcome, they have the lowest recidivism rate. So we are putting kids in the adult system unnecessarily. I think that's what we're talking about.
And you're going to get us a breakdown of what counties and how that is, like which jurisdictions are having these offenses and
Yeah,
remanding?
absolutely. I'll drop a county by county.
Yeah, or jurisdiction, I mean,
Yeah.
that would include this Baltimore City and the other counties. I'd like to see that, how many of these, because I can tell you,
And-
in law enforcement, as someone that's been in law enforcement for an extended period of time, there's times it's even hard to get for what might be deemed offenses that start children or young people in the pipeline of juvenile justice. It's hard to get them into the system because a lot of times they don't even want to come out, they're not taking them because they're like, oh, you know what, handle that. We're not getting counsel, or we're not getting the people to come out for
Right.
their evaluations.
Right.
So is that because it's a staffing issue, or is that a directive that's coming out that they're not coming out and helping law enforcement do their responsibility for the safety of the community while at the same time doing their responsibility to the community and the state as a whole by allowing the process to be in place to allow them to have access to the tools and health, things that could be beneficial.
Yeah, we should be absolutely partnering and making sure that we're providing youth services, early interventions. I mean, I think you've heard us all talk about how important it is to intervene early and intervene quickly and provide youth services that match their treatment needs. And so
Sure.
we're in agreement on that, I think, definitely. And I wanted to answer your other question about the youth that are coming back and the cases that are transferred back to juvenile court. 50% of them are crimes of violence and 30% of them are misdemeanor offenses. And the other the other percent is nonviolent felonies.
See the breakdown of those that are being remanded back and the jurisdiction that is remanding them back down,
Yep.
and by the category of the offense.
Yep, I
the
actually
violent
have
crimes.
like one copy of that, so I'll hand it to you. when
That
we're
would be
done with
great.
this.
I really appreciate it.
Absolutely.
Thanks for coming out.
Thank you.
Appreciate it. Mhm. Thank you.
Thanks, Senator Fulton. So if Nate mentioned the report for the Juvenile Justice Coordinated Council that was published in 2021. They have the breakdown there. So if you go to page 42, I'll make sure you guys get it. But
It's also linked here.
yeah, but they've got a pretty solid breakdown. So I'll make sure you get it. I think we had Senator Sinor, then Senator Carter, so Senator Carter.
Thanks, Mr. Chair. I want to make sure that there isn't confusion, because I feel like sometimes the more the discussion happens, there's more confusion. So, Ms. Anderson, first of all, thank you and welcome.
Thank you.
You have said a few times that 85% of children automatically charged as adults wind up with their case either dismissed in the adult system or transferred. Do you happen to know the breakdown of the 85%, like how many wind up staying in adult or have the case dismissed? Or I think that, is it dismissal, straight up dismissal, or is it some other outcome short of a conviction?
It's a dismissal in the adult court or transferred back to the juvenile court. So it's about 70% that are coming back to us and the 15% of the dismissal.
So that's what I'm thinking. So I just wanted to be clear that for those children automatically charged as an adult that are not transferred back, that are dispensed of in the adult system, that's a real issue, because I think that the belief is we tend to lean toward the fear, the worst, most awful offense, those children could put, God forbid, they should get to go to the juvenile system. But there's a significant number in there that are automatically charged as an adult that don't make their way transferred, but are just straight out dismissed, which indicates that either it really wasn't all that serious or the state just couldn't prove the case, right?
That's correct.
So it's not always the worst of all worlds. But
That's correct.
what I'm concerned about too is because we also keep talking about the offense, the nature of the offense. I know that this is lost on many people, and I'm sad that it is, but we're talking about the offense as charged. Very rarely in the criminal or juvenile system is the outcome of a case, even where there's a guilty finding, is the outcome of the guilty finding the same as the case as charged. Do you understand what I'm saying?
Yeah,
Correct?
that's exactly correct.
So for instance, let's say there are 5 children in a car, and the worst of all the charges is a carjacking. And then It's, several counts of carjacking, several counts of unauthorized use, several counts of auto theft, several counts of robbery, several counts of maybe even a deadly weapon. If those children are 14 and up, they're going to be automatically charged as an adult. But if they're not, and they're in the juvenile system, whichever system they're in, the chances that they're going to be found guilty of each and every one of those counts is highly unlikely. Isn't that correct?
That's correct.
And so I'm thinking of the kid that's the little, and I'm going to give the least culpable scenario, but I can also do one with the most culpable. So the kid that's 14, that's a tag-along to an older brother who's home alone with no real supervision, and his brother's the only person that he's got to hang out with. And one night, the brothers that are 16 and 17 decide to do a carjacking, and he's just there. And maybe a state's attorney decides, I'm going to look at everything and decide I'm not going to charge this kid with all of the worst of the things, because I think there's a distinction. But many state's attorneys may not. They may say, you're all there, you all get the same thing. But as the case goes down through the process.
Yep.
And they're all automatically charged as adults, and they're all put in the adult system pending trial. And the transfer hearing, if filed, if it's even filed, if they have an attorney that files a transfer hearing, from the time of that arrest until that transfer hearing is how long?
That's 114 days.
114 days. And
That's
so
on average.
for that time, which is more than 3 months, less than 4 months, those children automatically charged as adults. They are not getting services from the juvenile system. They're just being housed. Is it correct? They're just being housed.
Detained in the juvenile detention facility.
Well, they could be.
They could be, or they're in the.
Or they could not
Or
be.
or in a jail. Correct.
Right. So really, I don't want to belabor this, but you also testified earlier that the monitor had found like an astronomical number, like over 600 sight and sound violations.
Yeah, 600. I think.
Is that
67.
the population that we're talking about where those violations occurred?
That is correct.
I'm not going to digress, but I did want to circle back on that with you, Monitor, at some point, because that seems like a huge number, and I'm wondering, is it multiple violations for the same individuals or whatever? But that's a lot of violations for a small number of people, ostensibly. At any rate, so they wait for their hearing, and so it comes up to trial. And then it turns out that, maybe the little tag-along wound up, as the state's attorney looks further into the case and they get ready for trial, it turns out that kid is intellectually disabled, maybe even has some other type of a handicap or a disability, and really was not even cognizant of what was going on. And says, I'm just going to dismiss this person. So that person's just out, never transferred, nothing. So that is an example of someone charged with those worst of all things. Well, not the worst of all, because worst is rape and robbery, rape and murder. But carjacking, people will get very upset about that too. I think that's a heinous offense. I keep hearing it be called that a lot. That person's just out. So that person, that 14-year-old that winds up getting out and dismissed because really the state can't really prove anything because they find out he's not even competent to stand trial, much less knows what's going on. That person, that 14-year-old, had he been automatically charged in the juvenile system and potentially waived up or not waived up, during that same period of time between arrest and transfer or arrest and ultimate trial, which could be 2 years down the road, would have received services and programs in the juvenile system if held there, correct?
That is correct.
If charged there, I should say, if charged there. And what might those programs and services be?
So when a young person is held in our facilities, they're required to receive education, right? So 6 hours of education every single day. They have therapists that are trained to work with young people. They are able to visit with their family. There's no isolation, no timeout. All of those types of things are able to have programming. They're assessed by the department for risk. They could be able to not be detained and be on an electronic monitoring, be able to be served in the community while pending their hearing.
And so, Mr. Chairman, I don't want to take too much time, but I just think that these issues are more complex than somehow we attempt to simplify them into these horrible offenses and they're charged with this and this is what we should do with them. So, all right, so there were 5 kids I started with. So the other 4, they're 16 and 17. Guess what? It turns out that as the discovery is uncovered in the case, there was no weapon. There was no knife, no gun. And the prosecutor and a trial attorney files motions, and all the kids get transferred back to juvenile court. But that could happen, correct?
That can happen, yeah.
And because it's found there's no weapon, so maybe they even reduce the charge to like unauthorized removal of a vehicle. And so during that time that those kids get held, the difference is they are just held, charged as an adult, treated as an adult, nothing happens, and at the end of the day, they either get transferred back to juvenile, so there's a big gap of a waiting period between, that they're going to get the services they would have gotten to begin with. Or, they might stay in the adult court. Finally, I'm wrapping up in a minute. As a person experienced in the criminal justice system, more often than not, when a crime occurs, like something terrible that starts off like a carjacking, and then it's reduced down to something else because it doesn't have a weapon. And maybe it does, but I'm talking about the situation where it's not the worst of all. It's like kids being bad, being misbehaving, but not really being out to really harm anyone. It's possible, or even maybe probable, that a state's attorney would look at who's kind of the ringleader, who's the worst of all, who's the one that really went up to the person and took the car, and look at everybody else as like they were just there. So it's possible that in a situation like that, those other kids would have their cases dismissed in the adult system, correct?
That's possible.
The reason I'm bringing all of this up is I just want to highlight that the proposal that will come before us, that has been before us in the past, is one that doesn't determine at the front end what the outcome will be. It determines at the front end what all good science and most states that exercise best practices have determined, and what Maryland has determined in certain other instances, like when we decided that these same children could not marry, basically that under the age of 18, we are going to recognize this person as a child. Now, if they commit the most awful of all offenses, and it turns out that there's some validity to the offense, because first allegations happen all the time and they're not valid, that there is nothing in any proposal that would come before us that would bar a prosecutor from going to a judge and saying, you know what, this child is mature, this child has been raising 6 other siblings, this child has held down 3 jobs in the past, this child has behaved in all ways as an adult, and in this case, because this thing is so terrible, I believe that we have to charge this child as an adult. This child is an exception to the rule that says a child is a child, should be charged as an adult. There's nothing that would stop that from ever happening, correct?
That is correct.
But in the opposite situation, where the judge says, this child is intellectually disabled, this child can barely read and write, this child is illiterate, this child is not even capable of getting himself up in the morning, getting dressed by himself. Yeah, the act is bad, but everything about this child rings. We need to treat this child in the juvenile system. We need to get this child literate. We need to address this child's intellectual disabilities. We need to address this child's other kinds of needs. That is where the juvenile system would make a difference in terms of helping the child become a productive adult, but also protecting the public safety, because most likely they'd come out of the situation better. And I think that's all that people that believe that we should reconsider automatic charging in all of the offenses that we charge in are saying. Correct?
Correct.
Isn't that so?
Isn't that?
All right, so let's refer to questions. I wanted to one of the reasons why I thought this was important, just to get a base level understanding of how the system works. I just want to tag in real quick and then. So just, again, so you're talking, Senator Carter's line of question highlights 2 things. One is like the system, the 2 systems, and then one is the facility where folks are actually housed. So the question then begs itself, like, so why, if you're charged an adult or you're charged as a youth and you're under 18 or within 21, where are you physically? Are you in a juvenile detention center?
You're going to start, if you're automatically charged as an adult,
Yeah.
you're going to start in the jail. Right, you're going to start, you're going to be.
So you're going to be
you'll
physically
held
housed in an adult
in the-
facility.
In the adult facility, in an adult jail.
And if you're charged as a youth,
You're going to start in a juvenile detention facility.
right, so the question is going to be asked, why then, if there's sight and sound requirement, separation requirement, why can't youths who are charged either in the adult or juvenile system be given the opportunity to receive services regardless of the system, because physically they're separated? So that's the question that's worth asking, and I ask it here today.
I think that there's, when we look at jails and we look at their ability and how many youth are happening, they don't have the services or the capacity to work with those young people, right? So they don't have what is needed.
So there's no statutory prohibition, there's just a capacity issue or a logistical challenge? How does that work?
They're not designed to work with young people. The majority of their population is over 18, so they're not designed.
So I'm just pushing it a little bit,
Yeah.
just, we're going to get this question. Just, so then there's no way to bring services to those folks that are in an adult facility, even though they are youths?
No.
There's no way
I
to
mean,
physically do that. I'm asking.
Sure, but I think a lot of times, it's one kid at a time. So you have one kid, they're ostensibly, if you're holding them sight and sound separated, they're by themselves, so they're in solitary confinement. Even if you bring in the other, the other services, they're still by themselves in solitary. And then, I don't know if
Yeah, I was
Nate.
just going to say, you could spend an absolute fortune, trying to gear up Queen Anne's County Detention Center to take kids charged as adults, bring in educators. But why would you do any of that? Why would you try to change that? Why not use a maximum security juvenile facility that DJS operates, which already has a cohort of teachers and mental health therapists and et cetera, as well as the security apparatus?
And the staff.
Yes.
Staff are trained in, they're juvenile services employees. Their job is to work with young people in the juvenile justice system, as opposed to those who are working in adult jails who are not trained to work with the population at all, which is, again, young people are different. That they get specialized training in juvenile services to work with those young people.
Yeah. One other quick thing that didn't really, I think, hit home, and that's, Kara mentioned that the average, which is, a fairly startling number in and of itself, the average time that a kid charged as an adult spends just sitting on their butt with no decision, just waiting to see what happens with the charge, with the allegation, is a few months. I come across kids who spend over a year waiting. So we're talking very significant deterioration and decompensation, even in a pretty balanced individual mentally over that time, as well as the education level really going into the toilet. So it can be a very long time. And given that the vast majority of kids charged in that way end up back in the juvenile system ultimately, but with a much higher hill to climb, it seems like the burden of proof should be reversed at the beginning, and that the kids should start in the juvenile system with services, and then, if that kid is accused of, and there's evidence brought that that kid did something absolutely abominable, then I don't think that the burden would be that, I don't think it would be that hard for a prosecutor to make a good case, frankly. I'm not going to make the case for the prosecutor, but it shouldn't be that hard to make the case that perhaps that kid is an exception.
Excellent. Thank you very much for the answers. Vice Chair Walshricker.
Chairman, and thank you, Ms. Anderson, for your testimony here today. I have one question for you
Yes.
and a couple for Mr. Bayless. What is the recidivism rate for youths charged and tried as adults?
So the recidivism rate that I have right now, for you, and this is from the Department of Public Safety and Correctional Services, looking at their emerging adult population, youth that are 18 to 25, their recidivism rate was 44%.
No, my question is, for all youth charged and tried as adults, what is their total recidivism rate, regardless of the age at which they are released?
You want I can work on getting you that number, I don't have it.
Can you go back to the chart, please?
Are you asking about,
Yeah, when you have that data, could you add that to this chart so we have the three data points?
Yep.
Youth charged as an adult and tried as an adult, use charged as an adult and tried in the juvenile system, and use charged and tried in the juvenile system. That would give us all 3 data points.
Right, I can try and get that for you. I think that, the way that public safety counts their recidivism rate is a little bit different than how we look at ours, but I'll definitely work on getting that for you.
Thank you.
Yeah.
My next couple questions are for Mr. Bayless, because you've been very kind to provide kind of a 50-state view of things. How many states begin in a neutral position when it comes to youth who commit crimes?
Can you just, what do you mean by neutral? Meaning that they start in juvenile court? Is that what you're?
Well, so we are presented with a duality here that children can either begin in the juvenile system and be waived up, or begin in the adult system and be transferred down. How many have an adversarial hearing which is neither in the juvenile nor in the adult system, in which the judge is making a determination about which system they should proceed in?
I'm not sure how to answer the question, just in the sense that there's always going to be some original jurisdiction of there's either criminal courts or juvenile courts. I'm not aware of some sort of third neutral option there where cases start instead, but I don't know of that. There are places where all cases are started in juvenile court, and I think that's an important thing to make a distinction here. And again, in those places, young people can still ultimately be tried in adult courts. It's just that the case originally starts in juvenile court.
Each of you were very kind to talk about the benefit to individual determinations on the nature of the child, the nature of the offense, the nature of the circumstances. But as Senator West pointed out, we eliminate that individual determination at age 21. So how many states provide for a hearing at release that would allow some type of hybrid between both juvenile and adult confinement?
I think it's a bit of a tricky question, because there are states that have laws that allow for a sort of dual jurisdiction conviction, where they might be convicted in adult courts but kept in juvenile facilities up until a certain age, and then there's a decision that can be made at that time. What I don't know of is situations where if a young person is charged as a juvenile, there's not I'm not aware of one where then when they turn 21, there's some other provision that allows them to then move into the adult system. So there's sort of laws that allow sort of the flip to happen, where a kid might be charged as an adult. They're held in juvenile facilities up to some age, and in some cases it might be even older than 21. There are states that do that. Even when a kid's charged by adults, they're kept in juvenile facilities and older than even 21. And then there's a decision made about whether they end up moving to adult prison or not, but not when cases start in juvenile court.
Let me just tease that out a little bit so I understand what you're saying and that everyone understands what you're saying. So first of all, to start with, how many states allow confinement of youth beyond the age of 21?
For youth charged as juveniles?
For youth in any circumstances who are serving in the juvenile system, how many states allow the jurisdiction of the juvenile system to go beyond the age of 21?
I don't know the answer. I could tell you that I know that there are states that do that. I know, for example, New Jersey has that. I know that Oregon has that. And again, these are young people who were convicted as adults and then kept in juvenile facilities past their 21st birthday. But I'm not sure the full number of states that have that as a provision.
Thank you. I'd love to see that information if you can grab it. And then, so I just want to clarify, because I think I understood what you said, but I just want to grasp it. When you're saying that there are certain people who are charged and convicted as adults who begin their confinement in the juvenile system and continue it into the adult system, are you indicating that when that continuation into the adult system is made, that is done at sentencing? Or it sounds like you're saying there are some states that have an opportunity at age 21 or whenever juvenile jurisdiction is coming to a close for a hearing, a reassessment about whether the original amenability was appropriate and whether that person can be released or needs to continue rehabilitation in the adult system?
Yeah, there are states that have provisions that do something of that, again, for kids who are in criminal court.
Okay. And do you know of which states those are offhand, or is that something you might be able to provide?
Again, I just rattled off a couple where I know that young people may be housed as adults in juvenile facilities up past the age of 21, but I'm not sure of the full list of places that have those types of provisions.
Okay, got it. We'll work together and see if we can get that information.
But again, I think the most important part is that you have a juvenile justice system that is effective at working with young people. And I think the important thing, given what some of the questions were today, and I thought they're good questions, but again, is irrespective of the offense, the juvenile justice system is designed to work with those young people, is set up to provide services to them. There's no purpose in having juvenile correctional facilities in Maryland if they're not serving young people who pose the greatest safety risk in the state. Otherwise, young people should be held accountable in the community if they're not a public safety risk. And so I think Maryland stands ready to work with young people in the juvenile justice system. But yes, we can get all that information on how.
Everything you said, but where where it's clear to those who are providing the services that at an artificial cutoff point, those services can and should be continued to be provided for exactly the same reasons that you indicate, to prevent recidivism, to make sure the rehabilitation is complete, then we at least have an obligation to explore what other states are doing in that regard.
Thanks.
Senator James and series of questions about the facilities and where folks should be residing, regardless of their charge as an adult or as a youth. If they should be residing in a youth detention facility, is it a capacity issue or what? What's actually happening? And so I'm going to follow up on that, but Senator James.
Thank you, Mr. Chairman. Going back to the very beginning of the hearing, and I'm new, so I think I didn't catch a couple of things that maybe are in the council that could answer it. But I thought there was a discussion that this automatic provisions had been revisited and voted affirmatively to continue. Is that correct? Although someone challenged how that vote occurred, or there might have been some absences when the vote was taken. But someone just.
That was sorry.
I apologize.
Do you want to comment on? I mean, that was part of the Juvenile Justice Reform Council. I think, Josh, do you want to make that point?
We missed it, sorry. Can you ask one?
Yeah.
I'm so sorry, and really a short answer, Josh, I'm sorry. Did you say that especially the automatic provisions for when a child is charged as an adult, that kind of issue was revisited by some kind of committee, and it was affirmed, although you said there was some debate about the vote? Is that correct?
So, I mean, Mr. Bayless was on the council, so he can probably speak more specifically, but my understanding was the council voted to recommend eliminating automatic charging, but not all of the members participated in the vote, so that was the reason it didn't get into the bill last year.
Okay, good. Well, then I completely didn't quite get that. And is there any history on, rather than answer this here, is there any history on how these automatic provisions were developed and what was the thinking behind them? And if so, could you share that with me? Because I just like to get a little background.
Absolutely, I can drop something off to your office around that.
And then lastly, not fully still understanding this, I see that you have you discussed the automatic situation, and then I see a slide later on that says the youth is arrested, the arresting officer makes the decision of how to charge him with input from the state. So in one chart it says that it's automatic, sounds like no discretion. On another chart it looks like there is some decision-making and just some discretion early on in charging the youth on these two different slides.
Oh, okay, those slides aren't my slides, and I haven't seen them, so I apologize for that, but we'll talk real quickly about automatic prosecution and waiver. So kids, based on their offense and their age, can be automatically charged as an adult if they're 16 and 17, charged with those offenses.
Can be or must be?
Must be.
Okay.
They're automatically charged.
All right.
And then 14-year-olds and older, if they're charged with the first-degree murder, first-degree rape, first-degree sex offense.
That's what I understood. That's why I found this a
Yeah.
little confusing.
And then if a young person can be waived from the juvenile system to the adult system if they're 14, charged with those first-degree murder, first-degree rape, first-degree sex offense, or if they're 15 years old and charged with any offense, they can be waived to the adult system.
And then they can also be transferred down. So I know we don't like this automatic.
Right.
We feel there's no discretion, and we don't know the child, and we don't know the circumstance. So, and maybe you could follow up with me, because I don't want to delay
Yeah,
this
no
committee.
problem.
But it seems to me, once that automatic situation has occurred, I'm thinking a court has one more opportunity to weigh in, either to transfer the child back down to, so there is a review of this, or the request could be made on the other end, probably by the state, to waive the child up, in case the charging initially is not what some additional information seems appropriate.
Absolutely.
Is
and
that correct?
Yes,
how it
that's
works?
correct, I can come to your office and we can have a larger conversation about it. And what we were saying is that when that happens, that charge in the adult court, to then get to the juvenile court is taking an average of 114 days. And so that was the point that we were talking about.
And just one last, is that because we lack judge, what is the, trying to figure out different ways to help with this situation. What is the delay, and is it a matter of resources at the judiciary, or is it something else? And you can also answer that later.
Yeah, we
if you
can talk
want.
about it more later, but, I think it's some delays. It's the adult court system processing. They have different timeframes in the juvenile court, right? There's very succinct timeframes in the juvenile court. The adult system doesn't have that. There's no timeframe of when this transfer hearing is supposed to happen, so.
But there's no prohibition that we couldn't pass something that required a different time frame, just to
Correct.
make it a more accelerated process. Is that correct? Just thinking
That's
of.
that's one option, yeah.
All right, thank you. Thank you, Mr. Chairman.
Thank you, Mr. Chairman, and I think my interest is along the lines of the chair's interest. So earlier on, I said we were talking about 3 topics, all of which seem to have gotten conflated in this briefing today. One is, where should the trial occur? One is, where should the offender be housed prior to the trial? And the third is the transfer waiver system and how that works. So I've never understood why juveniles some are housed like in Baltimore County, in the Baltimore County Detention Center in an adult prison, and others are housed at Hickey, which is a very, if you're behind bars, Hickey's where I'd want to be behind bars. It's a pleasant park-like surroundings. Why is that? Is there a statute that says that someone who is now going to be tried in the adult court has to be housed in a adult prison prior to trial, and someone who's going to be tried in the juvenile court goes to a place like Hickey? Is that a statute, or is that a decision Department of Juvenile Services has made?
It's not a decision that the Department of Juvenile Services made. In 2015, there was a law passed that said that youth who are automatically charged as an adult and are eligible for transfer, so that's all kids except for those 16 and 17-year-olds charged with first-degree murder, can ask the court to be held in a juvenile detention facility pending their transfer hearing. So they go to their bail review and they can ask the court can say, yes, you should be held in a juvenile facility, or the court can say no. The presumption is that they should be held in a juvenile facility, but that doesn't happen all the
There
time.
would be no necessary reason why we could, as the General Assembly, could not provide that all people arrested as juveniles, whether they're going to be tried in the adult court or in the juvenile court, would be housed prior to trial in a facility where they could be given services, including educational instruction.
That's correct. That's just not how it's current. Yes.
Okay, and is there room, to your knowledge, in the juvenile facilities in Maryland to house the juveniles who are going to be tried in the adult court prior to the time of their trial?
Yes.
Okay, it seems to me this,
Yeah.
right.
Under this section to transfer its jurisdiction, the court shall order the child to be held in a secure juvenile facility unless yada, 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 yada. So the point was it a resource thing? Because why, I know that if you're charged an adult, you're still you'll start off in an actual adult facility, but why can't you just start them in a youth detention center?
Right. That would change, the booking.
I understand,
That
yeah.
process. But yes, that is a possibility.
So and then another,
Resources for that.
Yes.
In theory.
So it's individual
Yes.
court decisions are
Yeah.
kicking in, and it's the small number of offenses where it's not an option. Those are the two things.
And I know we don't have anybody on the other side here, there are no state's attorneys here, but can you give us what argument someone might make against the idea of housing all juveniles in juvenile facilities prior to the time of their trial?
I don't have any argument against that.
Okay.
And Senator West especially, because again, these young people are housed in those facilities, so it's not like there's some offense that
We can't.
we can't have them in the juvenile justice system. They're already there today in all of, yeah.
Was about the system and the physical location. Because if you were to have them start in the actual physical location, a juvenile detention center, then regardless of which system they're in, why could you not give them the services regardless of the system that they're in, logistically speaking?
Right, and we're already holding the
Yeah.
overwhelming majority of those young people in our detention facilities.
In
County Detention Center a couple of years ago. And it was pointed out to me that over in this area, there is one juvenile. And I said, so it's like he's being held in solitary confinement? And the answer was yes. And I couldn't figure that out. I also took a tour through Hickey. It would seem to me logical to house all juveniles prior to the time that they're tried, whether they're going to be tried in adult court or juvenile court, in a facility where they can get education and other counseling they might need, rather than in an adult prison.
Absolutely, and we're already doing it, and we have the capacity to do that.
Okay, thank you.
You're welcome.
Very much, and Kara and Nick, welcome. It's good to see you
Good to
again.
see
We
you
worked
again.
together for 12 or 16 years. We
did.
worked together on a number of these issues, and one of the things, Mr. Chairman, thank you for giving me this opportunity. You learned that some things never change. You worked for years and years and years, and the issues are the same. I think one of the things I hear you saying that may answer some of the one or two questions is that the argument is safety. I've heard on this committee, you take someone 12 years old and you put them in the same place with someone 17 years old, you got a safety issue. That's the only argument I've ever had. I never agreed with it, but that's what I've heard many times. A couple of questions. The biggest negative here from being within the adult and the juvenile is that you don't have, not that they don't have the capacity, but you just don't have the services. So you're sitting there in adult prison as a juvenile and you really have no services. Is that correct?
Correct.
And I think that what we were talking about, it can all be handled with legislation, because I'm trying to understand, as we've done this many times, I chaired the
strip search and
strip
shackling.
searches. And when I chaired that commission, I never understood why it was that just because a kid was 5 years old, 6 years old, they had to be shackled. And on the one hand, we say we don't want to treat them all the same, they're all differently, and yet on the other hand, we are saying they're all the same. I hear two arguments, and I've heard it. And there's no reason why they can't get the services other than in the adult jail, they don't have the training. Is that right?
That's correct. But I do want to make one point about that is, when we're talking about where kids are housed.
Right.
Right, and the length of time that process takes. And we're looking at that 114 days that kids are waiting for that
but no,
transfer
that's what I'm
hearing.
talking, yes.
So they're being detained unnecessarily for that 114 days. So yes, we can move them there, and they can be in those facilities, and the vast majority
still,
of them
no.
already are there, but they're still there for a school semester.
And Senator, just also, I would just add that, sorry.
sorry.
I'd also just add, Senator, that jails are not physically designed to house children.
Absolutely.
They're just not, they weren't built that way. Juvenile detention centers are tough enough, as Nick has talked about. They're plenty secure. Jails were not built with children in mind in their physical design layout, in addition to staffing and training and all that.
Thank you, and I really just wanted to welcome you.
Thank you. It's good to see you again.
Thank you, Mr. Chairman.
Mr. Chairman, you may have answered this question, so I apologize. So when was automatically charging youths added? Had it always been there? 20 years ago, 30 years ago?
It first started, I think, in the 1940s. The first charges in Maryland, I think, were for homicide charges, for murder was back then. Over the years, in the 70s, I think robbery was added to the list. And then over time, more charges had been added that total the 33 different offenses that young people are automatically charged as adults.
So if there was the option, this was taken away, and there was the option, is there some form of educating the state's attorneys about which way that youth should be charged? Is there going to be some kind of standards or regulations that, it just seems to me, state's attorneys have their own jurisdictions and their own thought process and areas of how do you put guardrails on there to make sure, I mean, what's the difference if you have somebody who's going to just charge everybody, not be an automatic, but just they take it themselves to just charge everybody? So are there guardrails that get set up?
I want to make sure that I'm understanding your question, so.
I'm not even sure I know my own question.
We'll work it through together. All right. So is your question that if we start with the waiver process, is there some guardrails for state's attorneys on what cases to bring?
Correct. Is there some
So
form of,
under the current law, no, it's just 15 years old, and any offense, they can ask the court for that case to be moved to the adult system, or those 14-year-olds with the first-degree murder, first-degree rape, first-degree sex offense. And I do want to answer the other part of your question that you asked, when those charges happened. About 20 of those automatic exclusionary offenses happened in 1994.
okay.
That was the super predator.
But what, in this
body, yes.
in this legislative body, if anybody knows, like, why was 1994 such a massive overhaul? Or was there some specific?
You can be honest.
I think it was, around the time of super predators and, that thought that, we should be scared of these kids. And I think that what we have found is that's not the case, and that the Department of Juvenile Services is able to handle those young people. And when we look at the recidivism rates, we're able to do that, and we have better outcomes for those kids. And we can do it, we're already doing it, and we have the capacity to serve these young people.
For the record, I was 11 and not here during that time. So.
We won't hold you
Even I
accountable.
wasn't.
Yeah.
I was 50 and I was here.
All right. Additional questions from the committee? I do want to follow up on the resource issue and the capacity issues, though. We'll do it offline, but
Okay, great.
I really do
Thank you.
appreciate it. All right.
All right, thank you.
With that, thank you all very much. This has been great. Thank you all.
Thank you.
With that, that'll end our hearings for the day. That's right. So you all know tomorrow, regular bill hearings, 1 o'clock. I'll make announcements on the floor, that's fine.